Welcome. Today, Group 1, Keola, Madeline, Victoria, and Whitney will be briefing you all on a case regarding digital evidence. The advancement of technology has been increasing throughout the years and is now being a main source of evidence in criminal court. Prior in criminal courts, the usual evidence that were used was surveillance videos, emails, witnesses, and phone calls, as well as text messages. Now, today, geolocations, as well as digital evidence such as Alexa, a virtual assistant, Fitbits, and in this case, an individual pacemaker. Digital evidence is information and data of value that is stored on, received, or transmitted by an electronic device. Whitney would now brief you on the case of Mr. Ross Compton.
Ross Compton is being charged with aggravated arson and insurance fraud after an incident that took place at his house in 2016. It is alleged that he set his house on fire, which ultimately cost almost $400,000 in damages. The cause of the ferocious fire is in question because Compton's statements caused the investigators to doubt the course of events. Ross Compton managed to gather several belongings by packing them in a suitcase and breaking a window to escape the burning house. His statements do not match or make sense to authorities who say that a man his age and with a pacemaker would have enough time to gather several belongings, followed by packing them, then breaking a window, hurl the packed bags, and then escape the blazing house without injuries. The caption reads, State of Ohio versus Ross Compton. Plaintiff's counsel wants digital evidence, such as information obtained after issuing a warrant for the pacemaker to be admitted in court during the trial against Compton. Now, Compton's counsel does not agree and argues that Compton's private information is being exposed by violating his physician-patient privilege or, quote-unquote, stealing personal information. On July 11th, 2017, plaintiff's counsel and defense counsel both went to a hearing to argue whether this type of digital evidence, which is the information gathered from defense's pacemaker, should be admitted in court. Compton's defense counsel does not agree with the state's procedure in issuing a warrant to obtain his client's pacemaker information because it is the very first time that a case of this nature makes such digital evidence admissible in court for trial. He also argues that the search warrant was not valid and that their client's right to privacy and specific medical information is being violated. One of the points that he made was that the warrant omits the name of Compton's cardiologist, even though investigators knew who they were getting information from. Defense counsel also argues that the search warrant used to obtain Compton's pacemaker information is basically a search warrant for a cell phone because it is not specific to the thing to be searched or item to be seized. In defense counsel's opinion, probable cause is not sufficient to have went beyond what it should have been allowed to go to protect the right of privacy of the defendant. Moreover, defendant did not affirmatively place his medical condition into controversy. Therefore, there was no reason to issue a warrant to begin with, according to defense counsel. The policies being violated is the Fourth Amendment, which gives people the right to privacy and against unreasonable searches and seizures. Also, the violation of the right of privacy between physician and patient, which includes medical data without the patient's consent and without the defendant in this case having it placed affirmatively into controversy. CPLR 4504A.
On the night of the fire at Mr. Ross Compton's house, there were individuals who either affected or was affected by this situation. Starting with Mr. Compton being the most important individual in this case. Mr. Compton has an artificial heart implant embedded into him. During the fire, Mr. Compton was able to engage in and accomplish things in a matter of time that it would be impossible for a person with his health condition would be able to do, which raised some concerns. Mr. Compton in this case represent all patients who have medical devices embedded in them and their privacy. With the data collected by the digital evidence and decisions that will be made can make or break future cases that allow this type of evidence to be used in a criminal court. Mr. Compton and his attorney oppose of this data being collected and used in court, stating that the invasion of his constitutional rights were violated. The first responders of this case, who happens to be Middletown law enforcement detective, also hold a major part in the case of Mr. Ross Compton. With major concerns of Mr. Compton's safety and defending the interests of an innocent man at that moment, the detective asked questions to possible help with how the fire started and could have possibly killed Mr. Compton. After hearing Mr. Compton's inconsistent story, suspicion raised, and thoughts of a real crime of arson and insurance fraud was happening right before their eyes. The detective then obtained a search warrant for all the electronic data stored in Compton's cardiac pacing device. This situation strained how other individuals be viewed and also ruins how other individual cases will stand at trial in criminal court with digital evidence. The detective opposed of using digital evidence to prove that Mr. Compton has committed fraud and arson in his own house. On the behalf of Medtronic, the company that makes the pacemaker embedded into Mr. Compton, is stuck in the middle. Many will question why was the information released. However, with the search warrant, the company's owner testified in court. The data that was taken from Compton's pacemaker included his heart rate, pacer demand, and cardiac rhythms before, during, and after the fire.
As for the decisions and outcomes, this has been an ongoing case, with the date of the trial being delayed several times. During the initial hearing in 2017, the judge decided to allow pacemaker data to be admitted as an evidence, despite the arguments of the defense attorney. It is a first-of-its-kind criminal case to use data as a criminal evidence from a device that is implanted internally. Mr. Compton failed to appear for trial in 2018, citing mixed-up dates. Judge consequently issued a warrant for his arrest. With the bail set for $100,000, Compton remains in jail. A psychiatric evaluation was ordered to confirm that Compton was competent to stand a trial. Defense argued that their client had a history of mental and physical illness, which prevents oxygen flow to the brain. A plea of non-guilty was submitted for a reason of insanity. The evaluation consequently confirmed that Mr. Compton was of a sound mind to stand a trial. As of April 2019, Compton and his defense are maintaining a non-guilty plea. They're also requesting a reconsideration of a decision on pacemaker evidence data, referring to doctor-patient right for privacy, instead of earlier submitted motion of invasion of constitutional rights. In court system, there was a first for every kind of digital evidence. First for Fitbit, first for Alexa, and first for pacemaker. There are at least 200,000 people in the United States that are utilizing pacemaker technology. There are also insulin-dependent patients that are using pumps that incorporate computer chips. There has been at least 2 more cases involving pacemaker data after Mr. Compton was first indicted in 2017. The impact could be severe, not only on the medical field, but also on the privacy of patients and also on the devices that they are using. Those devices, they share not only historical data, but also real-time data with the doctors. Tech companies such as Apple and Google are getting more and more involved into development of health tracking applications that record information which could be exposed by law enforcement in criminal cases. Heartbeat is no longer private and could be used as an evidence in court. But what should be also mentioned that the more data is collected, the easier it is for law enforcement to uncover the crimes. Advancement of technology is evident and it is happening at an alarming rate. Court systems need to adjust accordingly to the rapid change. As of right now, there is no clear distinction between data collected from inside the body and data collected on the outside by external device. Law enforcement routinely obtains blood samples and other medical records with search warrants. Balance is needed between rights to personal privacy and the extent of law enforcement involvement obtaining it.